Good afternoon, everyone. Welcome to another edition of Employment Law Q&A. I am Darren Sall. I'm an associate in Samfiru Tumarkin's Vancouver office. I'm here today to answer all of your employment and employment law related questions. Don't be shy. You can put your questions. I think we're live with YouTube and Facebook today. Fire away whenever you guys have a question. There is no question too insignificant, too small, or too large. I'm here for 30 minutes to answer any questions you might have. This is the best opportunity you'll have to speak with an employment lawyer, right now when you need it. If you do have questions that you don't maybe want to ask on the air, you're shy, or there's personal information involved, you can feel free to go to employmentlawyer.ca. And that's our website. There are a ton of resources on there. Contact information for lawyers, our intake team. We have an intake team, a massive department who's here to serve you across BC, Alberta, and Ontario. There are a ton of resources on there as well, blog posts, previous live streams, such as this one, where you can go on and listen to other people who have had similar questions to ones you might have. If you want to contact us directly and set up a consultation or speak with a lawyer who can assist you, you can go to help@employmentlawyer.ca, email us, and someone will get back to you very quickly to set you up for an appointment. Or you can call us at 1-855-821-5900. That's 1-855, and the number should pop up on the screen there below me, 855-821-5900. To get in touch with someone in our intake department to set up a consultation. You can also get quick answers to your employment law questions, some of them, at pocketemploymentlawyer.ca. So you can go online, go to pocketemploymentlawyer.ca, and this will give you access to our handy severance calculator. If you're in a position where you've been terminated or are staring down the face of a termination, or just wondering, what you may be owed in case you are terminated from your position. It's a great resource to give you a good kind of quick idea. I've got a number of things to chat about here today, but it seems like we have some questions coming through. So our first one for the day is Yuva from YouTube. And Yuva is asking, my HR at the beginning of my LOA, so leave of absence, in November 2021, non-union, said I'm not terminated and always argued it's not termination. From the employment law, is HR right? Can common law interpret it as a termination? And so this is a very good question. This is one that we're seeing a lot in practice right now, simply because of the vaccination mandates employers have been putting down due to COVID. So I'm assuming that that's the reason for the leave of absence, Yuva. And if it is, then you are entitled to treat that as a constructive termination of your employment, depending on the situations that surround it. If you've agreed to the leave of absence, however, that would complicate matters and may put you in a position where you cannot treat it as a termination of your employment. These are typically very fact-specific situations. It also depends on if a leave of absence is something that historically has happened in your work, such as if you're in a cyclical field of seasonal work or something of that nature. In the existence of an employment contract, which permits the employer to place you on leaves of absence due to the needs of the business, may also come into play as well. So, great question. I think you definitely have a situation here worth discussing with an employment lawyer. And so I'd encourage you to reach out to us in order to get a full picture. Some more details are required, I think, to fully answer your question. But to get a full picture of your rights and what you can do given your current situation, feel free to reach out to us, and we'll be more than happy to set up an appointment and talk you through this. We have another question here from Carlos Herrera Rebello off YouTube, it looks like. Carlos is asking, I have a permanent illness which makes it difficult to be on site. And I see a follow-up here. However, I can work from home. Do I have to tell my employer formally with a doctor's letter? So, Carlos, if you have a permanent illness which is new and was not present at the time you were hired, and there's nothing in place for you to do your current job, a doctor's note would be best to say that you are unable to be on site. And to request accommodation from your employer. Your employer does have a duty to reasonably accommodate any illnesses that prevent you from doing your job in a certain way. This is, again, a very fact-specific scenario. It would be best for you to reach out and have a talk with an experienced employment lawyer to help get some more details on your illness, on the type of work that you do. I mean, that will play into this as well. And to whether your job can reasonably be done from home and effectively be done from home. These are all important questions that we would have to dig into. But generally speaking, your employer, when you have an illness or an injury, your employer does have a duty to reasonably accommodate those in the course of you working. So yes, I would encourage you to reach out to us as well. help@employmentlawyer.ca. You can contact us. We'll get you set up for a consultation to have a chat with one of our experienced employment lawyers, and we can hopefully get you settled up. And we have another question through YouTube here as well. It's from JBK. This person asks, if you were placed on unpaid leave for 4 months and not entitled to severance because they had no choice to put you on unpaid leave and you're called back to work, can you sue for pain and suffering? Okay, so there's a couple different questions in here, I think. If you're placed on an unpaid leave for 4 months, your ability to claim a constructive dismissal after 4 months, I think, would be potentially compromised. But again, this is a very fact specific, so we'd have to know, a little bit more about your employment and the nature of the leave. You've stated here that the employer had no choice but to put you on an unpaid leave. So I'd want to know what led to them having no choice. To you being placed on an unpaid leave, at what led to that scenario. And if you're called back to work, you can't sue for pain and suffering in this sense. If you're placed on an unpaid leave, your recourse at the time, and it's always important to reach out immediately when something like this happens, to talk to an employment lawyer and to raise an objection with your employer at the time you're placed on the leave, to say, hey, you're placing me on a leave. This is not something that I agree to or consent to, because that's not something an employer is generally permitted to do in the course of your employment. In the course of your employment, they're not permitted to just place you on an unpaid leave. You are, of course, able to agree to an unpaid leave if you want to keep your job. But the recourse is if you don't want to be placed on that unpaid leave, you can raise an objection. I would suggest speaking with an employment lawyer before doing anything in order to protect your rights. And so you can have your claim and your rights protected and set up in the best way for success. We've got a follow-up from JBK, who says, I was told I'm not entitled to severance from a lawyer there located in a TDSB. I'm sorry, JBK. I'm not sure what TDSB stands for. I would suggest that you contact us and set up a quick consultation, because I think there's a bit more to dig into here. There's details that we'll need in order to fully flesh out what the situation you're facing here is. In order to give you appropriate advice on maybe how best to tackle the situation, or on what your rights may actually be in this situation. So we've got Randolph Buttermubs from YouTube, who asks a question. My brother's employer has reduced his hours significantly because they are currently not getting any new contracts. Is there anything he can do about this, or does he have to take the pay cut? So he doesn't have to take the pay cut in the sense that if his hours are being reduced, there may be an opportunity for him to claim a constructive dismissal of his employment at this time. The thing I think you have to look at is, what his entitlements are will depend on the presence of an employment contract. That can significantly limit your brother's entitlements on termination, and the decision as to whether he wants to ride out this dry spell, as it were, and in the hopes of the contracts picking back up and him getting work again. If this is just a slowdown in the business that maybe happens, based on seasons or something like that, he may want to ride that out. It's not possible for him to both claim a termination and continue to work at the business. So it's really a choice as to whether it'd be worth it to go after severance at this point, whether the facts would support that in this situation. Or whether he wants to ride that out and keep his job and continue with that. Generally in a situation where there are guaranteed hours, say you're hired on a full-time 40-hour per week basis, the employer makes a significant cut to your hours and significant corresponding cut to your pay, that will lead to a situation where you are able to claim a constructive dismissal of your employment. You can take that cut in pay and work as a termination. If you're only on an hourly and there are no guarantees of hours or anything like that, then it really depends on the nature of your employment. If you're in an hourly kind of contract-based work and your employment is predicated upon you receiving contracts or the business receiving contracts, and this was known to you and accepted by you at the time your employment started, then you may not be in a position to claim a constructive dismissal if this is something that was understood as a term of your employment, that your hours and pay was dependent on contracts that the business received. So again, I think this is a situation that you'd be well suited to have your brother contact an experienced employment lawyer to have a quick chat about some of the details of his position, any employment contracts in place, in order to fully suss out his rights. So again, you direct your brother to employmentlawyer.ca. I think the website should be up on the corner here for ease of access, and to speak to someone. You're welcome to search the lawyers there. You can get in touch with me personally and directly. Again, my name is Darren Sall. I'm an associate in the Vancouver office. And if your brother does work in any of the other provinces, Ontario or Alberta, we do have lawyers in both of those provinces as well that you can reach out to and schedule a consultation for. So we have a question through YouTube from JC204X. They ask, in the event of seeking new employment after recovering from a vehicular accident, what rights does an employee have for accommodation? And then there's two follow-up questions. I could see how a new employer might not want to hire under terms that alter job descriptions or give extra breaks. Would they be liable for discrimination in that situation? My thoughts are this might be difficult or hard to prove. So, you've kind of hit that right on the head. Is there, when hiring, there are different standards in place. If you cannot realistically do the job that you're applying for, then the new employer doesn't have an obligation to hire you. Accommodation typically comes into play where you're at a job, you're at an existing job. For example, you're working in a factory, you're getting into a motor vehicle accident, and you have ongoing, say, back and shoulder pain. In that sense, if you can no longer do heavy factory work or whatnot without the use of an assistant or without having some of your job duties offloaded, your employer in that case may have a duty to accommodate you. This duty to accommodate you in an existing employment relationship rises to the level of undue hardship for the employer. So the only time that the employer can kind of get away with not accommodating you is if they can prove that accommodating you would be an undue hardship on the business. And that's a very difficult thing to prove. A very high bar is set for that. So again, if you're in that situation, you may have a claim for discrimination if it's in an existing employment relationship. In order to pursue an employer for not hiring you in a new position, I mean, that would be very, very difficult to prove. They're not obligated to hire you if you can't do the job in accordance with the terms that they've set out for the position. If you don't meet the qualifications for the position, they're not obligated to hire you. That being said, if you let them know that up front, they may be in a position to accommodate you, because it may not be that is that big of a deal for them, depending on what level of accommodation you require. That's a conversation you could have with any potential employer. And we've got a couple questions here. We have a question through YouTube from Zuzona, and I'm sorry if I mispronounced that. She asks, I gave 2 weeks notice to my employer, was told to leave the premises immediately. They told the owner I quit without notice, and they blocked access to ADP, and I cannot access my final paychecks. What can I do? Thanks. So, Zuzana, you gave 2 weeks notice. I guess my question, if they told you to leave, would be, did you give this notice in writing? And if you did, even if you didn't, the 2 weeks notice that you provided, that's what your severance would be restricted to. In this sense, when you resign from a position, you're not owed severance, but your damages in this case would be the 2 weeks notice, because if they've essentially, from what I can tell, kicked you off the premises and told the owner that you quit without notice when you did give 2 weeks notice, you are entitled to those 2 weeks wages that you otherwise would have been receiving. So again, you can contact us and we can see what we can do to help you in that situation. You may want to reach out to the owner and provide them with whatever resignation letter. Hopefully you used a signed and dated resignation letter when you gave your 2 weeks, and if you did, you can provide that to the owner and let them know their obligations in that respect. Or again, contact us, and we're more than happy to talk to you and likely assist you in receiving what you're owed. We have a question through Facebook from Majid. And Majid asks, I was with a company for more than 12 years, 5 years full-time contract and 7 years permanent, but they calculated my severance according to my permanent years. Is that correct? So Majid, I'm assuming that there was no break in between the 12 years. Because potentially the break, if there's a break in employment between your full-time contract and your permanent years, that could complicate matters a bit, where they only would count your more recent time working with the company. But on the assumption that your 12 years was continuous and you went from 5 years full-time contract right into 7 years permanent, then no, it's not correct, unless there's another corresponding clause in any employment contract you signed when you went permanent that says they're only giving credit for time moving forward, and they're specifically not giving you credit for past service. So unless there's a clause in your permanent contract that says they're not giving you credit for past service, then you would be entitled to recognition of all 12 years of service when calculating severance. And then when looking at a severance calculation, if there's nothing restricting you to the minimum severance standards under the Employment Standards Act, at least in BC, you could be looking at a very, very big difference between 7 years and 12 years. You could be looking as much as 6 months difference, 6 to 7 months difference in the severance owed to you. Length of service is a very important calculator in terms of what severance you're owed. So I would encourage you to reach out to us. At employmentlawyer.ca. You can go to our website and you can contact any one of our employment lawyers or our intake team to discuss your rights and what those may look like moving forward. We need some more details as to whether or not there was a break in service in between your employment. But provided they're not, then no, your 7 years permanent is not all your entitlements should be calculated on. And so we have a question from Permchan Singh through Facebook, who asks, hello, I got injured on the job in 2019, went back out to work, and due to my injury, I cannot continue, so I had to resign. Am I entitled to severance? I worked 17 and a half years. So the difficulty here is if you've resigned from your employment voluntarily, then no, you would not be entitled to severance. I guess my question would be, did you raise any issues with your employer as to your inability to do your job due to your injury, and were any accommodations offered or made to you? Like, what were what was the nature of your injury and your resignation? Like, how did that lead to it? Did your employer essentially say that, listen, you can either do your job or resign, and in that case, you resigned? Um, we would need a little bit more detail in order to answer this question. Um, but generally speaking, if you resign from employment voluntarily, then no, you are not entitled to severance. But there seems to be a little bit more to your situation, so I would encourage you to reach out to us to have a chat in order to get a little bit more detail, so we can fully flesh out your situation. And so we have another question through YouTube again, and this is Julia Arcaris, and Julia asks, I have been working for a magazine company based in Las Vegas for the last 3 years. My employer said that I am in at-will employment and not owed severance. Is this true? I am in Burnaby. Okay, so Julia, this is this is a fun situation that you've got here. The U.S. view on employment is markedly different from that in Canada. In most states, especially Nevada and whatnot, are at-will employment, which means that they can terminate you for any reason at any time, essentially, and not pay you severance. It's really going to depend. I'm assuming you have an employment contract, as you're based in BC. Regardless where your employer is, unless you have an employment contract which specifically states that you are subject to the laws of Nevada or wherever your employer may be based, you're in BC, you're doing work in BC. Simply, because the magazine company is based in Las Vegas, my question would be, where is the work that you are doing predominantly targeted? Is it for BC? Is it online? Because you're working in BC, you're entitled, in my view, you're entitled to protections of the BC Employment Standards Act. Like I said, unless you have a specific clause in your contract which you've agreed to abide by the laws of another jurisdiction, such as Nevada or whatnot. So, if you've got an employment contract, reach out to us, reach out to me, and I'm happy to chat with you. You can send me a copy of the contract to look at, and we can have a talk and see what we can do to assist you. We have another question through YouTube. This is Janet Smith. Janet asks, on modified duties due to work injury have been written up 3 times in under 10 days and never written up in 4 years prior. Can they fire me while injured? I know I'm being targeted specifically pre-injury employment as a cross-border driver. So, Janet, in this sense here, they can't fire you because you're injured. If they do, that's discrimination, based on a physical injury. And you would have a claim for not only wrongful dismissal, but potentially discrimination. If they're writing you up, my sense is that they may be doing that in the hopes of backstopping some kind of cause termination where they don't owe you severance. We'd have to have a bit more of an in-depth chat about this, but off the top of my head, being written, not being written up in the 4 years you've been there. I'm assuming you've only been there for 4 years, but not being written up in the 4 years that you've been there, and then being written up 3 times in under 10 days, unless they're for extremely egregious issues, I can't see that being any kind of supportable position on their part. For things like a cause termination, which is what your employer may be going for, to establish that, the bar is inordinately high to deprive an employee of severance. For write-ups, there's got to be a process in place where they not only write you up, but typically there's a progressive discipline policy in place. And even when they do write you up, they have to give you a reasonable opportunity to not only address what they're writing you up for, but to make corrections. and to facilitate you to be able to correct those issues that you've been written up for. So I think 3 times in 10 days, and that is not a sustainable. All 3 Janet just came through again. All 3 write-ups are unjustified. They have not been allowed in office to use the washroom because of vac status as well. So yeah, I mean, if all the write-ups are unjustified, I would say, you're better off reaching out to us now, so we can have a chat about your situation. We can get up to speed on everything, and hopefully assist you with guiding you through your rights. We're running out of time here. I see we got about 3 minutes left, so I'm going to try to power through a couple of other questions. I apologize if I can't get to everyone's question today. I will be back again, and we have other lawyers who will be on doing these employment law Q&As very frequently. So you're always, well to come on at any time, ask anyone any questions, or reach out to us directly, either on the website. From the website, you can go to employmentlawyer.ca, reach out to any of our lawyers, or give us a call and reach out to our intake team to set up a consultation with us. So Jordan Christie asked through Facebook. Jordan asked, if you were to get a job in a startup and receive company stock as payment in lieu of a wage, what tax liabilities and forms would you as an employee be responsible for keeping track of and filing? So Jordan, that is a great question, but I think you're better off. I'm not a tax lawyer, so I would direct you to maybe contacting a tax lawyer to discuss that. I mean, we deal primarily with severance. And as far as what liabilities and forms you would be responsible for keeping track of and filing, I would direct you to either a corporate lawyer for that, or more likely a tax lawyer to answer that question. Sorry, I couldn't be of more assistance on that. And Julia, I see Julia, you came through again and said, my work is online. I do marketing and editorial work for them, and my contract is pretty thin. It just states my position and salary. They've also been using PayPal to send me my wages. Okay, so I mean, if that's the case, Julia, and there's nothing in your contract stating that you're subject to the laws of a U.S. state, then you would be entitled to BC employment law protections. And so if you are in the process of losing your job or anything like that, then I would say contact us, and we'll be able to dig into everything to give you a good assessment of your rights. I mean, if you've been there for 3 years, I mean, you could be owed as much as 3 to 5 months of severance. Depending on if there is anything in your contract that does limit you. But as you said, it's quite thin, then that may be what you're looking at. So I see we're coming to the end of our time here. So I'll take a quick second here, everyone. I'll be back in I think about a week or two, and you'll be able to ask me more questions then. Again, any questions you guys have, you can always go to employmentlawyer.ca. You can email help@employmentlawyer.ca. And you can call us at 1-855-821-5900 to connect with a member of our intake team, and who will connect you with one of our experienced employment lawyers, and to help navigate you through your situation.